come to order. Good morning, everybody. I want to welcome our witnesses, say how much I appreciate your thoughtful testimony. I've read it all. There's some pretty compelling stories. This is, from my standpoint, a very important hearing. As I've looked back at the laws written, designed to protect people that have the courage to come forward within government, to blow the whistle, to tell the truth, to highlight problems of waste, abuse, and corruption, potential criminal activity within departments and agencies. We have a number of laws, and they date back quite a few years. And with Mr. Devine's testimony, I added a new one. Didn't realize it went back as far as 1912 with the Lloyd-LaFollette Act, followed by the Civil Service Reform Act of 1978, then the Whistleblower Protection Act of 1989, and then the Whistleblower Protection Enhancement Act of 2012. And yet we still have problems. My own experience with this, having come to government pretty late in life, started really with the events with Secret Service in Cartagena. And then as we started looking at the reports being issued and written by the Office of Inspector General, the fact that there was retaliation, or certainly evidence of retaliation against members of that inspection team for being forthright. And then followed up just recently with our border security hearings, we had a Customs and Border Protection agent, Chris Cabrera, testify before this committee, contradicting some of the information from the Department of Homeland Security, but also testifying under oath, as all of you will be doing here today. And a few weeks later, a couple months later, he testified on March 17th, 2015. A few months later, right before another hearing on May 13th, 2015, this committee was made aware that Agent Cabrera was being scheduled for a hearing in front of the Internal Affairs. Now, I raised the issue with then still Deputy Chief of U.S. Border Patrol, Rob Vitello. And I stated, because of my Lutheran background, I'll put the best instruction on things. And I was assuming that hearing with Internal Affairs was all about being concerned about what he was bringing to the table and wanting to correct any errors within the Customs and Border Protection Agency. I'm not so sure that was the case. Fortunately, because we highlighted in our hearing that that Internal Affairs hearing with Mr. Cabrera was canceled that same day rather abruptly. So I have a certain sense that maybe that wasn't so innocent. They really had something else in mind with that hearing. So these issues are very serious. As a result, my office has set up a website, Whistleblower at ronjohnson.senate.gov. We've already had over 130 whistleblowers throughout the government contact our office, and what we have here today are 4 of the individuals that did contact our office. And I'm also mindful through Mr. Devine's testimony that probably the greatest risk any whistleblower incurs is when they contact Congress. It sounds like that is where the greatest retaliation can occur. So again, I want to thank all the witnesses for coming here. The purpose of this hearing is not to adjudicate the issues you have raised. And that will occur through a process, a procedure. The purpose of this hearing is to highlight, so the American people understand, so that this committee understands that once an individual steps forward and puts their career at risk, expose themselves to the type of retaliation that is unfortunately all too common, we want to hear what type of retaliation is inflicted on individuals and what form of retaliation, or what forms retaliation takes. So that's really the purpose of this hearing. I do want to caution people, there may be some areas where some testimony might come close to revealing classified information or law enforcement sensitive. I want to make sure we don't breach those restrictions. But with that, again, I want to welcome all of our witnesses. Appreciate your courage. Appreciate the courage of anybody willing to step forward and risk that kind of retaliation. And I'm looking forward to hearing your testimony and your answers to our questions with that, Senator Carper. Continue to delve into the subject with probably multiple hearings. With that, it is the tradition of this committee to swear in witnesses, so if you could all rise and raise your right hand. Do you swear the testimony you will give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God. Our first witness is Lieutenant Colonel Jason Amarine. Lieutenant Colonel Amarine serves in the United States Army and led a Special Forces team in Afghanistan in 2001, for which he received a Purple Heart and Bronze Star with V device, which denotes participation in acts of heroism involving conflict with an armed enemy. Lieutenant Colonel Amarine has raised concerns about hostage recovery efforts to Congress. Lieutenant Colonel Amarine.
Thank you, sir. Warren Weinstein is dead. Colin Rutherford, Josh Boyle, Caitlin Coleman, and the child you bore in captivity remain hostages in Pakistan. I used every resource available, but I failed them. One of those resources was my constitutional right to speak to members of Congress. You passed the Military Whistleblower Protection Act to ensure such access. But after I made protected disclosures to Congress, the Army suspended my clearance, removed me from my job, and sought to court-martial me. As a soldier, I support and defend the Constitution of the United States in order to have a government in which the voices of the people are heard. My team had a difficult mission, and I used all legal means available to recover the hostages. You, the Congress, were my last resort. But now I'm labeled a whistleblower, a term that's both radioactive and derogatory. I'm before you because I did my duty, and you need to ensure all in uniform can go on doing their duty without fear of reprisal. Let me be clear, I never blamed my situation on the White House. My loyalty is to my Commander-in-Chief as I support and defend the Constitution. Whatever I say today is not as a Republican or a Democrat, but as a soldier without allegiance to any political parties. In early 2013, my office was asked to help get Sergeant Bergdahl home. We audited the recovery effort and determined that the reason the effort failed for 4 years was because our nation lacked an organization that can synchronize the efforts of all our government agencies to get our hostages home. We also realized that there were civilian hostages in Pakistan that nobody was trying to free, so we added them to our mission. I assessed that both issues were caused by an evolutionary misstep that created stovepipes of our federal agencies. The Department of Defense faced this problem in the 80s as Army, Navy, Air Force, and Marines operated independently of one another, leading to the Goldwater-Nichols Act of 1986. Transformation on that scale literally takes an act of Congress. To get the hostages home, my team worked 3 lines of effort: fix the coordination of the recovery, develop a viable trade, and get the Taliban back to the negotiating table. My team was equipped to address the latter 2 of those tasks, but fixing the government's interagency process was obviously beyond our capability. Recovering Sergeant Bergdahl was a critical step to carrying out our Commander-in-Chief's objective of ending the longest war in American history. So I went to Congress in order to repair a dysfunctional bureaucracy to support our president. It caused the Army to place me under criminal investigation. I spoke to Representative Duncan Hunter because he's a member of the House Armed Services Committee. I needed him to buttress our efforts with 2 simple messages. The hostage recovery effort was broken, and because of that, 5 hostages and a prisoner of war had little hope of escaping Pakistan. It started to work. His dialogue with the Department of Defense led quickly to the appointment of Deputy Undersecretary of Defense for Policy Lumpkin as the hostage recovery coordinator for the Pentagon. This step enabled the DoD to act decisively on the Bergdahl trade once the Taliban sought a deal. But the civilian hostages were forgotten during negotiations. I continued to work with Representative Hunter to try to get them home. He set up a meeting between my office and the FBI. Then the FBI formally complained to the Army that information I was sharing with them was classified. It was not. The Department of Defense Inspector General has since reviewed the information through my DoD IG complaint and confirmed it was not classified through a joint staff review. But still I'm under investigation. A terrible irony a horrible irony is that my security clearance was suspended on January 15th, the day after Warren Weinstein was killed. We were the only effort trying to free all the civilian hostages in Pakistan, and the FBI succeeded in ending our efforts the day after a U.S. drone strike killed Warren Weinstein. Am I right? Is the system broken? Layers upon layers of bureaucracy hid the extent of our failure from our leaders. I believe we all failed the Commander-in-Chief by not getting critical advice to him. I believe we all failed the Secretary of Defense, who likely never knew the extent of the interagency dysfunction. But now I'm considered a whistleblower for raising these issues. There's been no transparency to the Army's investigation of my protected communications with Representative Hunter. The Army would not even confirm why I was being investigated for the last 5 months until this week, and they only did that because of today's hearing. Danielle Bryan and Mandy Smithberger of the Project on Government Oversight have been a godsend. Representatives Duncan Hunter and Jackie Spears stood up for me where nobody else in Congress did until today. I'm truly grateful for the opportunity to testify before you. The outpouring of support from fellow service members has been humbling. Worst for me is that the cadets I taught at West Point, now officers rising in the ranks, are reaching out to me to see if I'm okay. I fear for their safety when they go to war, and now they fear for my safety in Washington. Is that the enduring message we want to send? And we must not forget, Warren Weinstein is dead, while Colin Rutherford, Josh Boyle, Caitlin Coleman, and her child remain hostages. Who's fighting for them? Thank you.
Senior Special Agent with Homeland Security Investigations, a component under Immigration and Customs Enforcement. Special Agent Johnson has raised concerns about national security and criminal risks in the EB-5 program to her management and to the DHS Office of Inspector General. Ms. Johnson.
Seems we're all going to do that today. Chairman Johnson, Ranking Member Carpenter, and distinguished members of the committee, I appreciate the opportunity to speak before you guys today surrounding the issues of and obstacles with whistleblowing. I am a special agent. I've been with HSI for about 11 years. I've been responsible for investigating large transnational organized crime groups involved in money laundering, narcotics, and bulk cash smuggling. I won't bore the committee with any awards of accommodations, although I have received some of the highest honors of our department, and my OPM file reflects clearly our yearly promotions. After disclosing gross mismanagement, waste, and fraud that threaten general public safety, national security risks, and public corruption surrounding the EB-5 project, I was subjected to a significant amount of harassment and retaliation. With the approval of my chain of command, I began investigating the EB-5 Regional Center and a U.S. investor. Some of the violations investigated surrounding the project included Title 18 statutes of major fraud, money laundering, bank and wire fraud. In addition, I discovered ties to organized crime and high-ranking officials and politicians who had received large campaign contributions and promotions that appeared to have facilitated the program. I disclosed this to my management and later the Office of Inspector General, specific examples of national security risks associated with the EB-5 and the project under investigation. Some of those security risks coincided with what the CIA, the FBI, and the SEC have already discovered as well. During the course of the investigation, I discovered that EB-5 applicants from China, Russia, Pakistan, Malaysia had been approved in as little as 16 days. The files lacked the basic necessary law enforcement queries, and that was evident by the regional centers, SOFs, and applicants' 526s. I found over 800 operational EB-5 regional centers throughout the U.S. This was a disturbing number for me since the U.S. only allows 10,000 applications per year. I could not identify how CIS was holding each regional center accountable or how they were tracked once they were inside the U.S. In addition, a complete and detailed account of the funds that went into the EB-5 project was never completed or produced after several requests related to that investigation. it became evident that there was some serious and significant national security risks to that program. From the onset of the investigation, my management began getting complaints from outside agencies and high-ranking officials. As a result, I was removed from the investigation, and it was ultimately shut down and closed. Shortly after, I was escorted by 3 supervisors from my desk and out of my permanent duty station. I was not permitted to access my case files or personal items. I was removed initially over 50 miles in direct violation of Title V. My weapon and credentials were taken against the agency's firearms policy. My government vehicle was confiscated. Access to the building and all government databases was revoked. I was told I couldn't even carry or own a personal weapon, which is a constitutional rights violation. I've been placed on AWOL on 6 separate occasions, 4 of which were during my meetings and interviews with OIG and the OSC. When an adoption social worker tried to contact and verify employment, she was told that I'd been terminated for a criminal offense. I almost lost my 1-year-old child. I report to a building that houses inmates where parolees report and in an area that has the highest homicide and transient population in the U.S. I am continuously placed in dangerous situations with no way to protect myself or others. Management has willfully obstructed me from competing for any promotions and injured my prospects to promote. Lastly, after being contacted by the Office of the Inspector General on the EB-5 case and designated as a witness, the agency falsely accused me of misconduct during a border enforcement operation in 2011. The result of it resulted in termination recommendation. The allegations surrounding the termination have since been proven unfounded by the OSC, and the agency has recognized that. OPR produced an inaccurate bias report in an attempt to terminate my employment and remained in contact with the same chain of command who had shut down the EB-5 case. This is a direct conflict of interest. The 2011 complaint was used after the agency was unable to substantiate any allegations against me and as a tool to ensure that I OIG or continue the investigation into the EB-5 program. There are no policies in place which limit the disciplinary actions against agents. Agents are placed on administrative restrictions for years at a time, which is a gross mismanagement and a waste when these agents are needed to support cases and protect the U.S. I was slandered to the point that I couldn't perform my job because of the malicious and false gossip. Took away the time and happiness from my family, and I'm still currently being held hostage by my own agency. It's demoralizing to myself and agents to have directors and senior leaderships bury their heads in the sand and ignore the reports of undue influence and surveys that clearly identify agents wanting to do their jobs but being unable to because of the leadership. It condones and it encourages bad behavior within the Department of Homeland Security. I'm here to inform the PD at an agent level of the retaliations surrounding one of the largest investigative branches of the federal government. Agents and officers need to be valued by management, not punished, when they disclose factual and important information to our leadership. In closing, it's important to have agents at your front line, coming forward on issues that affect the safety of our nation. To this committee, I look forward to listening to your insight and answering any questions you may have. Thank you, sir.
Thank you, Ms. Johnson. Our next witness is Mr. Michael Keegan. Mr. Keegan is a retired Associate Commissioner for Facilities and Supply Management at the Social Security Administration. Mr. Keegan has raised concerns about waste within the Social Security Administration. Mr. Keegan.
Chairman Johnson, Ranking Member Carper, and distinguished members of this committee, thank you for this opportunity to discuss my demotion, reassignment, and retaliation during my tenure at the Social Security Administration, or SSA. In July 2011, I was recruited by former Deputy Commissioner of Budget, Finance, and Management, Michael Gallagher specifically, to assume management and responsibility for the Office of Facilities and Supply Management, known as OFSM, an organization of approximately 500 employees and contractors operating and administering management and real estate actions for hundreds of SSA facilities across our country. In January 2012, I was assigned as the project executive for the construction of a replacement computer data center. This project was funded via a $500 million appropriation as part of the American Reinvestment and Recovery Initiative. Congress had been briefed by SSA officials that the appropriation was needed to replace the existing National Computing Center, or NCC, located on the SSA headquarters in Woodlawn, Maryland. Most notably, the replacement data center occupied only one floor of the entire National Computing Center with approximately 75 employees. However, an additional 925 employees work in the building's other 3 floors. The centerpiece of the justification presented to Congress was that the NCC was beyond economical repair, in terrible condition, and had to be replaced in totality. My duties further required attendance at quarterly congressional staff meetings before the House Ways and Means Subcommittee on Social Security. SSA was required to brief the committee on the progress and costs of the NCC replacement project. I was an important member of SSA's delegation. In the course of performing these duties, I discovered a number of serious problems at SSA. I first brought these problems to the attention of Assistant Deputy Commissioner of Budget, Finance, and Management, Ms. Tina Waddell, who did not act on my recommendations and instead instructed me to brief the new incoming Deputy Commissioner of Budget, Finance, Management. In February 2013, Mr. Peter Spencer was brought out of retirement by Acting Commissioner Carolyn Colvin to assume the duties of Deputy Commissioner. Soon after Mr. Spencer's arrival, I gave him a detailed briefing on serious issues that I believed included misleading Congress, waste and abuse. I further raised employee overtime and travel abuse issues. However, the most significant issues I raised involved SSA's representations to Congress to replace the entire National Computing Center, when at most only the part of the NCC that held SSA's data center needed replacement. As an example of this lack of candor, testimony on the record from Patrick O'Carroll, SSA's Inspector General, references the National Computing Center replacement with the National Support Center data center. Page 3 of that testimony notes that SSA representative was monitoring and improving NCC plumbing conditions, foundations, and monitoring HVAC ductwork as examples. This was no mistake or misunderstanding. SSA was specifically advised by an independent assessor to revise a Jacobs engineering report to directly address the committee's inquiries on construction costs and future use of the NCC. SSA refused to follow this recommendation and chose not to be forthright with Congress. And further, there was no mistake. In depositions, my attorney specifically asked and clarified from Ms. Colvin and her top aides that SSA never had any plans to replace all 4 floors or the entire National Computer Center. Attached for the committee's review are Exhibits 5 through 7 deposition transcripts which demonstrate this lack of candor. I asked the committee to pay special attention to Ms. Colvin's deposition transcript where she denies knowledge of that which National Computing Center employees do, where she testifies that she never saw the reassignment letter that ruined my career, a letter which she signed. Notably, her testimony that her chief of staff made the critical decisions against me, which was squarely contradicted by her chief of staff's testimony, which stated she made those decisions. I asked the committee to read pages 41 to 46 of Mr. Spencer's testimony as an exhibit, in which he dances around basic questions about whether he would consider purposely misleading Congress to be unethical. Mr. Spencer actually testified that he could not affirmatively say that purposely misleading Congress is necessarily unethical. Shortly after my report to Mr. Spencer, I was removed from the quarterly congressional staff briefings. A week later, a formal investigation was launched against me. Although I was cleared from the completely fabricated discrimination and hostile work environment allegations, I was removed from my position and left to languish in an empty office with a few tasks that a junior administrative employee could complete. To this day, after 22,000 pages have been turned over by SSA in discovery and 10 depositions by my attorneys, nothing has been shown by SSA that I deserve this retaliation. In July 2014, after blowing the whistle again on Ms. Colvin for misrepresenting to Congress the success of a $300 million disability case processing computer system, I finally made the very difficult decision to retire from government service 5 years earlier than planned, which has caused me significant hardship. I'd be pleased to answer any questions that the committee may have for me. Thank you.
Thank you, Mr. Keegan. Our next officer with the U.S. Customs and Border Protection in Washington, D.C. Officer Ducos Bello has raised concerns about overtime abuse at the Customs and Border Protection to the Office of Special Counsel. Mr. Ducos Bello.
Good morning to all. Chairman Johnson, Ranking Member Carper, and members of the committee, thank you for inviting me to appear before you today to help you blow the whistle on retaliation. I am a former member of the United States Army Aviation, and I served with dignity and honor for over 6 years until honorable discharge, because during a military operation in 1993, I suffered a severe injury which incapacitated me to perform my duties for 60% of my physical ability to continue flying. Of my duties, after my recuperation, I decided that I would like to continue serving the government as I dreamed when I was a child, raised in Aguadilla, Puerto Rico, next to the Ramey Air Force Base, where I enjoy watching all those B-52s going into practice during the Cold War. And I say to myself, one day I'm gonna be up there. Well, God gave me that opportunity. Moreover, I spent a year in Walter Reed in a body cast, recuperating from my injuries. And with the help of my wife and the physical therapist, I started walking again. And I've proven testimony that to this day I can do law enforcement work with all my pains and aches. When I was early discharged in 1995, I immediately took a position as a U.S. Customs Inspector in San Juan, Puerto Rico, where I made a lot of good things for this nation, and I continue serving with pride, honor, and dignity to this day. When I joined in 95, I completed to this day 20 years of active service with the service that is now the Department of Homeland Security, U.S. Customs and Border Protection. Sadly, because I did the right thing, I have suffered retaliation from the people that I would have expected to receive support and complete admiration for doing the honorable thing. Because I remember back in 1986, as I did just now when I raised my hand and swear to tell the truth, I also swear to protect the Constitution of the United States against all foreign and domestic enemies. Well, members of the committee, we are dealing right now with domestic enemies. Enemies that have no intention of respecting the Whistleblower Act and protect the people that do the right thing by reporting wrongdoing in the government. I reported the fraud, waste, abuse, and abuse of authority of more than $1.5 billion of taxpayers' money. And all of us in here are taxpayers. And I am an American citizen, and I'm proud of that. And I'm also proud of serving this nation as a public servant. All of us are public servants. We're not entitled to anything but to do our job for future generations so that this nation prosper and continue for many years to come. We don't want to see the United States and burned up like Rome did hundreds of years ago. I don't want to say that I am swinging for Republicans or for Democrats. That's not the issue as stated over here. This is bipartisan. And my duty from the moment moment I got this badge and a weapon to fight for America in a war and two conflicts is to defend the Constitution of the United States and to kiss all glory every time I can. Because that's my pride. That's my legacy to my children. If I'm here, it's for a reason. To leave a legacy to my children. And as Senator Carper was saying earlier, we have to protect the way that we spend federal funding. Nobody is entitled to say, well, forget about it, it's the government money. No, it's my money, it's your money. Every time you file taxes every year, it's your money. I have to say that CBP should avoid right now wars that they cannot win. And never raise your flag for an asinine cause like fraud and corruption. I have been made the villain, the black sheep, the inconvenient truth to the Department of Homeland Security. And that has to stop. I know we have many provisions in our system to protect whistleblowers, but the agencies, they don't care. And they try to cover it up as much as I can. My situation is well known. I have been suffering. I lost my job at the Commissioner Situation Room. I cannot go back. And gladly, with the help of the Senate and the Office of the Special Counsel, I am getting there. I'm gonna get my job back, even if it is the last thing I do. Because I worked there for 11 years and I never did anything wrong to deserve what is coming to me. I also, with the help of this committee and the help of the OSC, I am trying very hard to have the OSC power over their investigation, because the agencies do not respect the way they handle their investigation. And I want to end with a quote that President Obama, our leader in charge of this great nation, when he said, democracy must be built through open societies that share information. When there is information, there's enlightenment. When there is a debate, there are solutions. When there's no sharing of power, no rule of law, no accountability, there is abuse, corruption, subjugation, and indignity. I have been called many things. People laugh about my accent in Spanish. People might say that I'm a colorful character. People might think that I am just a second-class citizen. And I remember Senator John McCain telling me, if you are, Mr. Douglas, a second-class citizen because you were born in Puerto Rico, then I'm riding the bus with you because I was born in Panama. There is no place in our government, in our society, to reprise, to discriminate against people that do the right thing. I am one against many, and look what I did. I'm still standing, I'm still here, I have a job. And I want to do my job with your help. Also, I would like to cite something that helps me go by every day. Honor is simply the morality of superior man. Believe that you can do something and you're halfway there. And like Theodore Roosevelt said, speak softly and carry a big stick. So, in conclusion, let me find my paper. I have everything in order here. My professional reputation has been tarnished in public and social media, and my family has suffered the ill effects to my well-being. These are the facts and the evidence that I have provided to the staff of the committee. It will be much, much, much more. I will never do my 6 minutes if I tell you all the retaliation things that my agency have done to me. It's in writing and it's accessible to you as evidence. But more now than ever, I will ensure that all federal employees feel secure to report acts of corruption, waste, or security concerns that can bring grave danger to our national security. When it comes to federal agencies committing acts of wrongdoing, we are not scandal. We are the undercover cops on the lookout to prevent Uncle Sam from being pickpocketed. Thank you very much, and I'm looking forward to answer any questions that you may have for me.
Devine. Mr. Devine is a legal director of the Government Accountability Project, a nonprofit, nonpartisan public interest organization that assists whistleblowers. Mr. Devine.
Thank you. The testimony from the last four witnesses personifies why I've spent the last 35 years working at Gap instead of getting a real job. And today's hearing is welcome, much needed oversight for the marathon struggle to turn paper rights into reality. Working with over 6,000 whistleblowers since 1979, one of the primary lessons that I've learned is that passing these laws is just the first step on a very long journey. And today's witnesses did just a great job of sharing lessons learned based on their personal experiences. I'd like to extend that to the bigger picture. And the first lesson to be shared is one that I think is pretty obvious, that whistleblowing through Congress can have the greatest impact making a difference against abuses of power that betray the public trust. In our experience, no other audience comes close. But correspondingly, the second lesson is this makes Congress the highest risk audience for whistleblowers. And that's because there's a direct linear relationship between the severity of the threat posed by a disclosure and the viciousness of retaliation. Since Congress has more impact, it's higher stakes in both directions. The third lesson is that retaliation doesn't end. After blowing the whistle, employees face often a lifelong struggle for professional survival. This is a life's crossroads decision. The fourth lesson that I think is worth sharing is that since the WPEA was passed, creative harassment tactics are circumventing its mandate. These are very serious challenges. The most all-encompassing is the sensitive jobs loophole. This is a national security loophole that would subsume the entire civil service rule of law that's kept the federal labor force nonpartisan and professional since 1883. There's been no empirical studies or basis for scrapping the civil service system. There's no structure in place for a government-wide replacement or alternative to it. But the Federal Circuit Court of Appeals, the same court that forced passage of the WPEA, has approved it. Last Friday, the Office of Personnel Management issued final regulations. It is full steam ahead. Under those rules, the government has uncontrolled power to designate almost any position as national security sensitive. Once that happens, sensitive employees no longer have the right to defend themselves in an independent hearing. They don't even necessarily have the right to know what they were charged with doing wrong in order to lose their designation to work for the federal government. Now, the administration has said, well, we're not attacking the Whistleblower Protection Act, but that's very disingenuous. The agencies will still have the authority to present unreviewable, independent justification for their actions, even if retaliation is proven, loss of the sensitive job designation. And that means that by definition, every whistleblower will lose a case who has a sensitive job. We can still have the Whistleblower Protection Act to give you the right to lose and turn the WPEA into a bad joke. Unless Congress acts, we're on the verge of replacing the rule of law with a national security spoils system, and taxpayers will be the big losers. The second creative tactic that I'd like to highlight is criminalizing whistleblowers. As we've seen from this morning's testimony, a new tactic is instead of just trying to fire someone, put them under criminal investigation, and then give them the choice of either resigning or facing a prosecutive referral. This is very attractive. It's much easier, much less muss and fuss than litigation. You have to prepare formal charges and depositions and legal briefs and hearings and lawyers. All you need is one good investigative bully. Second, you can't lose. The worst that'll happen is the agency will have to close the case. And then next month they can open up a new case on a new pretext. I had one whistleblower who faced 30 years of serial criminal investigations. He was fighting bribery in the Chicago meat yards. The third factor is the chilling effect of facing jail time is much more severe than the chilling effect from possible loss of your job. The fifth lesson learned is that the Whistleblower Protection Act is a work in progress. The two most significant structural reforms for the Act to achieve its premise have not yet been finalized. GAO must recommend whether, like almost every other group of employees in the U.S. labor force, federal government whistleblowers will be able to enforce their rights through district court jury trials if they don't get a timely administrative ruling, and normal access to appeals courts. The All Circuits review provision of the WPEA is just an experiment. Senators, these are the structural cornerstones for the WPEA to work. The GAO report is due in a year and a half, and it's time for them to get started on it. The sixth lesson learned is that we're overdue oversight reauthorizing of the merit system agencies that implement the WPEA, the Office of Special Counsel, and the MSPB. The good news is that the leaders of these two agencies have really an unquestionable commitment to the merit system in their agency missions. It would be silly to challenge their good faith. And in both agencies, their performance is probably the highest in the history since they've been created in 1978. The bad news is this is a very low bar. At the MSPB, while the full board has been very even-handed, the administrative judges are still extremely hostile to the Whistleblower Protection Act. I can't honestly tell employees that they have a fair chance of justice doing an MSPB hearing. And at the Office of Special Counsel, despite a 600% increase in corrective actions, that's brought us up to 2.6% of people who file complaints there, which means that although they're doing a lot better, whistleblowers still don't have a fighting chance at justice when they try to act on their rights under this law. The bottom line, the WPEA was a great first step. The commitment of the agency leaders charged with enforcing it is an outstanding second step. But we've got a long way to go before we achieve the Act's purposes. There's a lot of work, and thanks for holding this hearing to help us get started.
I thank you, Mr. Devine, for your testimony. As I'm listening to it, you're coming from the private sector, where when you're at the top of a company, it's always kind of hard to get the information not filtered so that you really get the truth. I mean, as I'm hearing what was brought to the attention of superiors, I'm thinking you ought to be having memos pinned to your chest, not have retaliation inflicted upon you. So what I'd like to ask the whistleblowers here, I want you to very, hopefully as easily as possible, describe to me why. Why were you retaliated against? I'd like to start with Lieutenant Colonel Amory. And I appreciate you meeting with me in my office yesterday. I just want to, because you told me an awful lot yesterday, which I appreciate. I think I maybe have your why, but I want you to confirm this. You told me that in the course of your attempts to gain the freedom of these hostages in Afghanistan, Pakistan, you were made aware, it's your belief, that the government did pay a ransom and that ransom money was stolen. And secondly, that you believed you were pretty close to potentially having a deal where we would get 7 hostages in exchange for 1 Taliban leader. And instead we got 1 hostage in exchange for 5 Taliban leaders. Is that kind of in a nutshell, that information, is that why you've been retaliated against, or what is the reason?
Yes, sir. I think that there are layers of this, as I said, in terms of layers of the bureaucracy. On December 1st of 2014, Representative Hunter submitted a complaint to the IG alleging an illegal or questionable ransom possibly being paid for Sergeant Bergdahl. There was a good deal of evidence that it occurred and a lot of questions as to how it occurred. That complaint implicated both the DoD organization and the FBI. So part of what lit the fuse was the same folks in the FBI that were basically implicated in the DoD IG complaint of 1 December were the ones that later complained to the Army that I was sharing sensitive information with Representative Hunter. Another aspect of it on the FBI side was, I think, just the general frustration with Representative Hunter pushing them hard on civilian hostages and their awareness that I was speaking to Representative Hunter about all of this. I mean, he even set up a meeting between my office and the FBI to try to help them out with, and after the meeting, they responded by contacting Caitlin Coleman's father and threatening him not to speak to Representative Hunter again or he would stop getting supported by the FBI. I mean, just an atrocious treatment of family. So the FBI complained to the Army, and for reasons to be seen, there was a bit of a debate within the Army whether I actually did anything wrong. And my understanding is one party, who I just don't want to be speculative, but there was a big debate within the Army over whether I did anything wrong, and that led to the investigation.
Can you tell me a little bit about what deal you thought you had for the release of the hostages?
So, my office worked options. We looked at a whole variety of options. One of the options that we developed was we called it, the 1 for 7 option. It entailed 6 hostages and a 7th person I'd just rather not discuss today. So the 6 hostages, there's actually 5 hostages and a prisoner of war. So Sergeant Bergdahl, Caitlin Coleman, the child she bore in captivity, Josh Boyle, and Colin Rutherford. When we saw that nobody else was trying to get them home, we were working every initiative possible. One was the 1 for 7, and in that we were looking at Haji Bashir Nourzai. He was described as the Pablo Escobar of Afghanistan, and we realized that he actually is just another warlord who's actually an ally of the Karzai regime. We lured him to the U.S. under a false promise of safe passage and basically unsealed an indictment and put him in jail for life. Some felt he was a wretched human being, and others felt he was wronged. As we looked at the options, we looked at 5 for 1, which we thought had died in 2012, as the worst option. And so for us it was, we aren't getting Bergdahl, let alone the other hostages, back for free. Every option was going to be painful. So the Nourzai option for us was one that was at least less painful. So we were able to reach out to the Nourzai tribe itself that we believed could free the hostages, and we made a lot of progress on it. I briefed it widely, but in the end, when the Taliban came to the table, the State Department basically said it must be the 5-for-1. That's the only viable option we have, and that's what we went with.
I can see how members of the government, if there was an option for 7 or 6 Americans for 1 Taliban, and the deal ended up being 5 Taliban for 1 American, they probably wouldn't want that too highly publicized. So, okay.
Thank you, Mr. Chairman, for your strong efforts to uncover the truth of what's occurring before us today. Ms. Secretary, I appreciate you being here today. Yesterday, I had the opportunity to stand in front of polling locations during a primary where hundreds of concerned citizens of both political parties expressed to me their shock and outrage that the president would release 5 terrorists who they believe will have a background of having been facilitators of the attacks of September 11, 2001. We know the Taliban allowed the Al-Qaeda to operate from safe havens in Afghanistan to attack the United States. And for the top leadership,
you were part of the legislative branch as a member of the United States Senate. We make the laws. You're part of the executive branch now, which the responsibility to enforce the law. Whose responsibility is it to interpret the law? Is it the president's responsibility, or is it the courts?
The courts.
Then why did the president make the decision, or you make the decision, not to notify Congress?
We believe in the Justice Department, or Office of Legal Counsel,
Part of the executive branch
told the president that he had the constitutional authority to do that. He had, under his constitutional powers, the authority to make the decision that he did.
You said that you would put American lives at risk if the Taliban prisoners that were swapped in the secret deal would rejoin the fight, if they rejoined the fight in Afghanistan. What if they rejoined it from somewhere else? They don't have to necessarily be on the battlefield in Afghanistan. Certainly we would pursue them wherever they are.
We would do everything we needed to do as we have said, to deal with that threat, as we are doing today.
Your testimony is we're doing everything that we can
to deal with the threats to the United States of America, whether they're in Afghanistan, whether they're in Yemen, whether they're in Homeland Defense. It isn't just limited to Afghanistan, the threats that face this country.
Mr. Secretary, you keep saying we can't get the facts from Sergeant Bergdahl until he returns home. Have you ever thought about going to Landstuhl and talking to him there?
Well, I don't know how much medical training you had, Congressman. I haven't had much. And what we are doing is we are allowing
I'll tell you what, Mr.
the doctors.
No,
Mr.
Mr. Secretary, wait a minute. Why hasn't he been returned to the United States? We have seriously wounded soldiers that are returned to the United States almost immediately after they are stabilized. How long did Jessica Lynch wait before she was returned to the United States? You're trying to tell me that he's being held at Landstuhl, Germany because of his medical condition?
Congressman, I hope you're not implying anything other than that.